Welcome back to the Michigan Business Beat, brought to you on the Michigan Business Network. Chris Holman here, coming to you from my studio, but Jeff is down at our studios at the Capital Region International Airport. So we're going to be on the air, and we're running down to, actually, we're in Lansing today. Usually we catch this guy in Southfield. Anthony Dalimonte, he's an associate with Foster Swift Collins and Smith PC in Southfield and all over the state of Michigan now. It's kind of hard to keep track of you guys. Tony, welcome back. How you doing?
I'm good, Chris. Always good to see you. Thanks for having me.
Good to see you. And nice on the air rather than in a restaurant somewhere, you know.
Absolutely, absolutely.
Somehow every time Tony is in Lansing, I'm in the same spot and we wind up running into
We're
each
trying to beat each other for a sausage, egg, and cheese sandwich.
Oh my God, and they are. Don't talk about them, okay? I got to concentrate here. Hey, let's go to the NCAA today because now that the tournament is over, etc. There's a lot of legal issues. The NCAA. Tell me about that deal, what it is, and why it's so important to college athletes.
Yeah, so there was a lawsuit filed a couple years ago by Grant House, who is an Arizona State swimmer, and Sedona Prince, who is a TCU basketball player. And the lawsuit alleged that the NCAA's restrictions prohibiting basically revenue sharing for broadcast rights violated antitrust law. And, we don't have time to get into it, but the NCAA has a long history of lawsuits filed against it, that violate antitrust law. And we've kind of been building up to this point. And the House settlement, as it's called, is a $2.75 billion settlement that the NCAA is probably going to settle with these plaintiffs, and it's going to sort of set forth the framework for the future of college athletics, and it's a really big deal. So, we've been watching it closely. There was actually a hearing on it on Monday for approval. Now, I watched it. The judge didn't rule from the bench, but it's anticipated that she will give her ruling sometime in the next couple weeks.
So she still has to approve this, and what do you think is going to come out of this? That's a lot of money,
It's a
Tony.
lot of money. It's a lot of money. So there's two big pieces of it. There's a back pay piece where it's a class action. So former student athletes could submit a claim, and it's basically for their name, image, and likeness rights. And so that big $2.8 billion, a lot of that goes to back pay for former college athletes. Now, the other piece of it is there's an injunction piece, which sets forth the next 10 years of college athletics. And, we don't have time to get into it, but essentially the settlement directs the NCAA to set up rules to sort of somewhat regulate the NIL payments that we've seen. There's going to be a clearinghouse where all NIL payments have to be reported to Deloitte, and it kind of sets up. And I'm sorry I didn't mention it, but revenue sharing is the huge piece of this. So now schools will be able to revenue share up to $20 million, or it's like 22% cap of their broadcast money. So it's a new world that if this gets approved, we'll be entering into. I think it's going to get approved. Lots of schools have already started preparing for what this new world will look like. And frankly, I think it'd be tough to put the toothpaste back in the tube at this point. The judge may have some modifications, but I think it's ultimately going to get approved.
But the judge does have that discretion then that she can look at it.
Yep, she does. There's a number of objections that she heard at the hearing. Objections were with regard to collective bargaining and Title IX and roster limits and all of these types of issues. I think the judge listened to them and she may have some modifications, but again, I would be surprised if it doesn't ultimately get approved.
Well, I think it's a good idea putting some regulation on NIL because that can certainly get out of case for the big names. Now, what about the non-revenue sports? Are they going to participate in this?
Yeah, so how it works is the schools will be able to opt into this revenue sharing arrangement, which means that the schools then have a pool of money to allocate however it wants. And the presumption is that a lot of that money will go to football and basketball because those are the sports that generate a lot of revenue. I think there's some concern on the non-revenue sports side that, we're gonna kind of be left hanging out here. And the other big change that comes with the settlement is there's no longer any scholarship limits. It's now roster limits. And so, taking baseball, for example, we've got the Big Ten up here. It's very different than, SEC baseball schools. And so those schools may allocate more money than the Big Ten does to baseball, in which case coaches are fighting to keep their players and, working on having resources available. So there's lots of unknowns right now, but, it'll be interesting to see.
Well, listen, I wanted to plug for a second the Foster Swift Sports Law Group. I would have no idea how to sort this thing out, and all I would look at is, oh boy, now we're going professional, right? Because that's what it looks like. Tony, thanks so much for jumping on. Tony Dalimonte, associate with Foster Swift, Collins and Smith, who have offices all over the state of Michigan, and obviously a sports law group. Thanks for sharing, buddy. Appreciate it.
Chris. Yep.
You're watching the Michigan Business Beat on the Michigan Business Network. I'm Chris Holman. We'll be